So friends, as a former president of the United States prepares to turn himself into the authorities for the fourth time, let's talk about why District Attorney Fani Willis actually can take Donald Trump to trial in a timely manner. Because justice matters. Hey all, Glenn Kirshner here. So friends, what do we know about Donald Trump's RICO case in Georgia? Well, we know there are 19 defendants indicted, 19 criminal associates, 19 co-conspirators. What else do we know? Well, we know that Donald Trump is scheduled to turn himself in to Georgia state law enforcement authorities on Thursday. And we know that Fulton County District Attorney Fani Willis has asked for a March 2024 trial date. Let's start with the reporting, and then let's turn to why a timely trial, maybe even a speedy trial, is actually possible in Georgia. But let's start with some of the reporting. This from Reuters. Headline: Prosecutors propose March 2024 trial date in Trump, Georgia case. And that article begins, the district attorney prosecuting former U.S. President Donald Trump on election interference charges in Georgia has proposed that his trial start in March of next year, a date that would have Trump in court mid-campaign for the 2024 Republican presidential nomination. The proposed March 4 trial date is one day before Super Tuesday, during which voters in more than a dozen states are set to cast their ballots for the Republican presidential nomination. Then here's some of the reporting regarding when Donald Trump will surrender himself to the Georgia state authorities. This from CNN. Headline: Trump expected to surrender to Fulton County Jail on Thursday or Friday next week. And that article begins, former President Donald Trump is expected to surrender himself to the Fulton County Jail at the end of next week on Thursday or Friday, a senior law enforcement official with knowledge of the surrender told CNN. Trump and 18 co-defendants were charged on Monday in connection with a plot to subvert the 2020 election results in Georgia. After the 41-count indictment was unsealed, Fulton County District Attorney Fani Willis set an August 25 deadline for their surrender. Negotiations between Trump's lawyers and Willis's prosecutors are expected to continue into next week ahead of the surrender deadline. The exact timing of Trump's surrender remains unclear. And I think there's actually some updated reporting indicating that it looks like Thursday will be the day that Donald Trump, former president of the United States, will turn himself in to the Georgia state law enforcement authorities, will have his mugshot taken, I believe for the first time, will be fingerprinted, I don't know, for the third time, the fourth time in his criminal cases, and thereafter he will be presented to the court. He will be arraigned on his RICO indictment, and the judge will have to take up his conditions of release. We'll be talking more about that in the future. But now I want to turn my attention to the prospect of a timely trial date for Donald Trump in his Georgia RICO case. And what I want to do is sort of use my own personal experience as a former prosecutor handling RICO cases, large RICO cases in federal court in Washington, D.C., because some of the cases I handled had some pretty strong parallels to the Georgia case. Now, not with respect to the nature of the defendants, but certainly with respect to the size of the case and the number of charged defendants. And I want to talk through with you all how we worked through having to prosecute, a sizable RICO conspiracy case with lots and lots of defendants. That presented challenges, the same kind of challenges that are presented by this large RICO case down in Georgia, but I want to talk about how we worked through it. So let's dig in. So when I was a Department of Justice prosecutor, specifically I worked at one of the DOJ field offices, the United States Attorney's Office for the District of Columbia, we indicted a large RICO case. I believe it was the largest RICO case ever brought in federal court in Washington, D.C. More than 24 defendants were indicted. And then by the time we got to trial, there were only 13 defendants left, right? All the other defendants had pled out. They pleaded guilty, some with cooperation, some without cooperation, but there were 13 defendants remaining that had to be tried. When you look at the Georgia case, yeah, it's starting with 19 charged defendants, but 19 will not go to trial. Once defendants see their name in black and white on the wrong side of the V, State of Georgia versus the named defendants, tends to get their attention, and I suspect you're going to have multiple defendants decide to plead guilty, perhaps with cooperation, perhaps without. 19 will not go to trial, I strongly suspect. So we ended up with 13. Now, here is the reality, and I think it's a reality basically across all jurisdictions, federal and state. The courtroom security concerns will largely drive the question of how many defendants can go to trial in any one case, in any one trial at the same time. What I can tell you is in the District of Columbia, the United States Marshal Service had a pretty hard and fast rule, though it may have been an unwritten rule, that they could only provide adequate courtroom security for 6 defendants at a time. And that drove the decision-making train, right? So the reason for that, people may or may not know, that when folks are providing courtroom security, like the U.S. Marshals, they have to have a certain number of marshals to protect the judge, to protect the court staff, to protect the jury, to protect the prosecutors, to protect the defense attorneys and their clients, to protect the public, the audience members. And the U.S. Marshals in D.C. said 6 is the limit. And we were bound by that. Frankly, the judge, the court was bound by that. They took their direction on courtroom security matters from the U.S. Marshal Service because that is a crack outfit in my experience, having worked with them for decades. So what did we do? Well, we had to decide which 6 defendants to take to trial first, which defendants to take to trial second, and because we had 13, which defendants to take to trial third. So we did a series of 3 separate RICO trials. The first one involved 6 defendants. That case was tried by some colleagues of mine, some remarkable prosecutors and public servants, headed up by Tim Heafy, my friend and former colleague. You've probably seen Tim quite a bit recently during the January 6th House Select Committee because he was the chief investigative counsel. He is the one who really orchestrated, in many ways, the January 6th House Select Committee investigation. You've seen Tim more recently on MSNBC. He has been talking about his experience heading up that investigation, the congressional investigation into the insurrection. He did remarkable work, and he is one of the finest public servants I have ever worked with. So Tim and his team prosecuted the first 6. Me and my team prosecuted the second 6. And then there was 1 RICO defendant left because we did 6, but remember I said there were 13 who went to trial. So I had to do a 3rd RICO trial against 1 defendant, and even that one took me 3 months to try. So here is what I suspect will happen down in Georgia based on my experience prosecuting that large RICO case. I have a feeling that District Attorney Fani Willis may have to break up her prosecution into a series of separate trials or waves of trials. Now, let me tell you, it took us about 3 years to get through all 3 of these trials. But the first one was tried in a timely manner, pretty quickly. Here is what I think will probably happen down in Georgia. Now, full disclosure, I've never prosecuted cases in Georgia, so I can't swear that they will handle it exactly the way we handled it in the courts of the District of Columbia. But as I say, courtroom security concerns are pretty universal across all jurisdictions. It may be that Fani Willis will propose a modest batch of defendants for trial 1. It could be 2, 3, 4, 5 defendants. It will probably depend on how many defendants have pleaded guilty and so are no longer part of the trial. And it may very well be that she will say, you know what, we'll do our first RICO trial against just Donald Trump, Rudy Giuliani, and Mark Meadows. I'm just using those 3 co-conspirators, those 3 criminal associates, those 3 charged RICO defendants as an example. And then she'll say, we'll do 4 defendants in the second trial and the remaining defendants in the third trial. You know, the numbers will be driven by how many defendants really want to go to trial versus defendants who want to save themselves, who want to plead guilty, who want to try to make right what they did so very long when they were fighting to undermine our democracy. I always welcomed cooperating witnesses. I would sit down with every one and I would say, you've done so much wrong. That's why you are an indicted defendant. And the decisions you've made in your life have gotten you right here, you know, in a secure interview room where we brought you over from the jail if the defendant is detained pending trial. Why don't you try to make a different decision? One that will help you save yourself, one that will help you reduce your possible or potential jail time at the end of the day, and one that will actually be in furtherance of the rule of law and our democracy. You have a big chance here. And lots of people would take that chance rather than going to trial and looking at spending the rest of their lives in prison. Many of them in the RICO conspiracy cases I handled took that opportunity to make a change, to cooperate, and to testify about the crimes of others. It's a smart thing to do. It's the right thing to do. It's the moral thing to do. It's the patriotic thing to do. And I suspect lots of defendants will take that opportunity in Georgia. But I am hopeful, friends, and I've spent a lot of time now talking through my experience. I think it applies to the circumstances down in Georgia. I am hopeful that we see the first trial in the Georgia RICO case that Fani Willis just brought to include defendant Trump and maybe 1 or 2 others. And that trial can, and I think should, and I'll go so far as to say will, be set in a fairly timely manner. Hopefully that will be resolved well in advance of the November 2024 election, because I have said several times now, in the horrific event Donald Trump is the Republican nominee for the 2024 presidential election, people need to know, people deserve to know, when they go to the polls to vote for the president in 2024, whether that person is a convicted felon or a completely exonerated defendant who has been cleared by a jury of all charges. How likely is that? Well, friends, stay tuned, because with 4 criminal indictments of Donald Trump, one of these trials will come to fruition fairly soon, probably early 2024. Tough to say exactly which one, but Donald Trump will be tried. Donald Trump will be convicted. Donald Trump will be sentenced, punished, and I believe imprisoned for his crimes against we the people and against our democracy. because justice matters. Friends, we're getting there. We're getting there. Please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.